I have 1201, so maybe we can
Yeah, that's
we'll
fine.
we'll start gradually, not get into the real important stuff right away. But as an overview, and I think we've talked about this in prior seminars, Maryland workers' compensation system is a permanency system, meaning that once an injured worker's condition reaches maximum medical improvement based on medical evidence, then you can terminate temporary total disability indemnity, and then they go to a permanency rating. Other states are wage loss states, such that if they're off work, they get wage loss benefits for as long as they're off work or until you can prove they're better or you have a job for them. So there are different aspects, benefits and negative aspects. I think the Maryland system rewards people for going back to work to some extent, whereas perhaps other systems like Pennsylvania, there may be a fairly minor injury, but you could have fairly significant amount of indemnity owed. So
Yeah.
uh,
No, I was going to say, I completely agree. And if we make many times today, as we're discussing this, we'll make comparisons. I tend to compare to Pennsylvania because I also practice in Pennsylvania. So does Jack. And Jack's correct. Something in Pennsylvania, you have that minor lumbar sprain strain. As long as you have a doctor that keeps you out of work, you're going to keep getting the TTD. And you could even have an IME that gives you a full recovery. Depending on the judge you're in front of, you may win, you may not win. Whereas Maryland, once you hit that MMI and you get that opinion from a treating doctor or from an IME doctor, you can immediately cut them off. So yes, I agree with you, Jack, that it rewards people for going back to work. And I think if you talk to a claimant attorney as an injured worker, it would be, well, if you get back to work. It's never, I think it's a little different in Pennsylvania. Well, if you can find a doctor that's going to keep writing you off, have them write you off.
I guess the other interesting perspective is when I was young and had hair, I practiced in California. And when I came back to Pennsylvania, a lumbar work injury resulting in surgery in California at the time was worth like 25,000. I come back to Pennsylvania, it's worth like 125,000. So fairly significant difference. Another difference between Maryland and Pennsylvania. Pennsylvania has the reasoned decision standard, so you get a fairly detailed decision from the workers' compensation judge, and then you can appeal based on error of law. But the findings of fact are not appealable. Whereas in Maryland, you get a decision after like a 5-minute hearing that might be a sentence long or maybe a page long. There's no reasoned decision requirement, but then you have the right to de novo appeal. De novo appeal goes to the circuit court in Maryland, and so you could be, before a jury on an appeal. So appeals in Maryland are really limited, probably 5% or less, given the cost of an appeal. So when you go before the Workers' Compensation Commissioner, that's primarily your only shot to win your case. So,
and not to be too basic, but in Maryland, you are dealing with commissioners rather than judges, and they are very informal hearings. Like Jack mentioned, they are sometimes 5-minute hearings, especially when you're dealing with permanency. And we'll get to this, but when you're dealing with permanency, it's, the questions are quite limited, because at that point they've reached MMI. Are you still having problems? Can you do the stuff you did before? But you're in and out. Unlike Pennsylvania, where it's serial hearings and you're taking depositions, you're not doing any of that in Maryland before the commission.
and then when you get to appeal, you are doing that. The other thing you have to deal with in an appeal is that the commissioner's opinion or award is presumed correct, and so you have that weight on you in terms of trying and appeal a decision from the commission, and it is rebuttable. So some people likened it, if you have evidence is equal on both sides of the equation, then the commission's decision will be sustained. Whereas you can develop certain things on an appeal that maybe you didn't have the opportunity to do before the commission. So,
and we always talk, you always bring this up, Jack, and I always enjoy this. because you go to circuit court on appeal, and that's a tiny percentage of cases, and then an even smaller amount of those percentage of those cases would then be appealed to the next level. There is a dearth of case law in Maryland when it comes to workers' comp, and we always compare the two. I've got the book we use in Pennsylvania that we call the Bible, is several inches thick, full of case law. It's a tome. The book for Maryland is, half as thin, and it's not filled with case law. And it's, the way I don't think that will ever change so long as appeals are taken to the circuit court in Maryland.
So now, how about we move on to a compensable claim? And I don't know if you want to start it off, Steve, with the inquiry regarding accidental injury and whether it arises out of and in the course of employment.
Sure. There's four what I would call four elements to any injury in Maryland. The first is that it has to be accidental, and the way the courts have interpreted that is, in order for it to be accidental, it must be from some unexpected, that's from the claimant's perspective, strain, exertion, or condition from the employment. And an example of that would be, I'm working in a warehouse and I bend down and pick up a heavy box and I feel the prototypical pop in my back. That's accidental. And then the next thing that has to have occurred is an injury. And that is the claimant's burden. They must show through medical documentation that he or she has suffered an injury. It is possible to have an accidental occurrence without an injury being suffered. In fact, Jack, didn't you have a case in which you won by proving it wasn't, or am I mistaken? I'm sorry, I thought we've discussed that in the past.
And I recall, I mean, what we have discussed in the past, I think we had a whole seminar, I believe, or webinar on dealing with accidents at home. And then we covered this in quite a bit of detail.
Correct, because the third prong is arising out of, the injury must arise out of a nature, condition, obligations, or incidents of the employment. And it also has to be in the course of employment. And that we have discussed. And I don't want to get into too much detail because we literally spent an hour on home injuries. But with COVID and with the fact that you have a lot of people working from home, for an example, I'm working from home today. So if I'm doing laundry while I'm working from home and I go to change the laundry in the basement and I fall down the steps and fracture my spine, is that in the course of my employment, Jack?
That's the second inquiry. Course of employment is sort of a time and space and purpose kind of inquiry. But as we pointed out in, I think, a seminar or two ago, in terms of case law update, there was a case about a fireman in a firehouse where he wasn't necessarily required to spend the night, and he got up to get a sandwich in the middle of the night or something, and he tripped, and that was found to be a compensable injury, even though he was just spending the night in this random firehouse for his own convenience. So it's a squishy standard arising out of in the course of employment, as it is in other areas too, other states and things like that.
And I also like to always note, when we're talking about it in the course of, specifically, unlike Pennsylvania, in which an assault by a coworker would most likely not be compensable, in Maryland, assault by a coworker or a third party is deemed a compensable injury, even if the dispute arises entirely from personal, if it's a personal dispute unrelated to work. And I've had cases in which had people working closely with knives in kitchens, and one coworker stabbed the other coworker multiple times, and ultimately that was compensable, not just for the injuries, but then for the scarring benefits afterwards.
I guess another aspect of that is idiopathic injuries. In Pennsylvania, it's broader than it is in Maryland. In Pennsylvania, if you fall on concrete and you hurt yourself due to an idiopathic condition or a work-related condition, such as lightheadedness or something unrelated to work, you still have a work injury for any injury that occurred when you fell on the floor. Whereas in Maryland, it has to be something about the employment environment to contribute to the injury. So instead of just walking across the floor, falling and hurting yourself. Maryland requires that it be something more about the employment location, such as you're on a ladder and you fall off a ladder due to an idiopathic condition. So that's an aspect. I guess, Steve, when you were saying about accidental injury, and as far as it must be from some unexpected strain, that almost seems like whether the injured worker did it to himself willfully. So that would also be excluded from Maryland. And then we have the usual, well, I'll take that back. Another aspect of the Maryland defenses on arising out of in the course of employment, intoxication defense is more viable in Maryland than it is in other states such as Pennsylvania. I think Pennsylvania, you have to prove it was the cause of the injury. And in Maryland, it's a lower standard. So I had a case, 4 or 5 years ago when someone died in a motor vehicle accident, but he was intoxicated. They didn't even file a claim for that. In Pennsylvania, they probably would.
Absolutely, they would in Pennsylvania, because it's so difficult in Pennsylvania to prove that intoxication was the but-for cause of the accident. So very difficult. And I also wanted to mention, like many states, consequential injury. So if I hurt my low back and I'm going to physical therapy and I'm then injured during physical therapy, that injury through physical therapy would also be compensable in Maryland. How about some defenses? Talked about the intoxication. The other popular, there's other defenses such as the going and coming rule. Like Pennsylvania, if the employee is traveling to or from the workplace, those types of injuries would only be compensable in certain conditions. But for the most part, traveling to and from work, those injuries would not be compensable.
Yeah, and that's just like other states are grappling with that. I mean, again, during the discussion about case law update and injuries at home, this fella was walking to his car from his home. The case in discussion was around whether or not he worked from home or had a home office. But he slipped and fell on the way to his car in his driveway. And so that case went to a hearing on whether or not that was a going and coming exclusion from compensability or not. So you have those same inquiries in other states as well.
And the other two most common defenses: willful misconduct. If an employee knowingly violates a rule, procedure, or company policy, and the violation is the cause of injury, that would be excluded. And then horseplay. If an employee initiates or participates in a horseplay, they're not entitled to compensation. So I don't, how often do you see those? At least willful misconduct perhaps, but horseplay I haven't seen all that often. You, Jack?
Well, not in Maryland, but in Pennsylvania, where they were working in a warehouse with razor knives and doing like kung fu karate chopping.
Yeah.
So that provisionally was found compensable in Pennsylvania.
And I think we can move on. I don't think we need to spend too much time, but occupational diseases are also compensable in Maryland. How about hernia? Don't you recently have a hernia case, Jack? Compensable hernias?
Let's see. Before we move on to that, I think we had a question.
Do. We got a question.
And in fact, I mean, that's
the
violation of a positive work order. I mean, that came up in that case with the fighting with razor knives. The employer didn't do anything about it when the employer knew they were doing that type of activity. So that played into that case.
And it would be the same thing in Maryland if the employer is complacent about the horseplay, it could be found to be compensable. And there's another question: assault by a coworker. Does that have to occur at work, on work premises, or could it happen off premises as long as they were working? I think it could be off premises as long as they are working. If the other elements are met, if they're in the course and scope and arising out of, it would still be compensable.
That's right. In terms of hernias, another distinction, Pennsylvania doesn't have a limitation that Maryland has in its statute. Primarily that if a hernia, if there's a pre-existing condition, a pre-existing hernia, it's an aggravation of that pre-existing hernia isn't compensable unless it's a material aggravation that caused an immediate need for an operation. So that's something to look at for if someone claims a hernia condition and then doesn't get surgery for another 8 months or a year, then that's not arguably, that wouldn't be compensable. In fact, there was a recent case in the case law update where I think a claimant's attorney tried to get around this restriction in terms of compensable hernias and requiring immediate need for surgery by filing it as an occupational disease to get around that statute. And the court did not allow the claimant's attorney to do that, and it was barred under the statute dealing specifically with hernias rather than try to claim it as an occupational disease.
Right. And Jack, moving on, jurisdiction, as far as jurisdiction in Maryland, what injuries or what accidents fall within Maryland's jurisdiction?
Well, I guess the Maryland has a restriction for extraterritorial or out-of-state restrictions that if it's incidental employment in Maryland and you're injured out of state, then that would be non-compensable under Maryland. And the one restriction that Maryland has is for coverage for out-of-state injuries is that the employee would have coverage in another state, and then also that the restriction, the employee is covered under the other state where the injury occurred, and the other state would also exclude Maryland employees, you know, that are injured in, say, Virginia, that are I guess Virginia, if Virginia had a similar law as Maryland, then not covering out-of-state employees unless they had a similar law such as Maryland. And in Pennsylvania, for example, if you're injured in Pennsylvania, that's going to be a compensable claim. So this limitation of excluding non-resident employees from having having a compensable injury would not apply because Maryland or Pennsylvania doesn't have the exclusion. If you're injured in Pennsylvania, you're going to have a Pennsylvania workers' compensation claim. So right. Sorry, Steve, if you want to clean that up.
No. Yeah, and for the most part, all accidents that occur in Maryland would be compensable, except if see above what you were just talking about. But yeah, and I had a case that was dual jurisdiction where the gentleman was injured in Pennsylvania with a Maryland employer, but he was also a Pennsylvania resident. And for whatever reason, it was picked up under Maryland law. He received benefits. And then, of course, he obtained an attorney in Pennsylvania. They filed a claim petition. There was no doubt jurisdiction also lied in Pennsylvania. So we ended up picking up that claim. And honestly, it should have never been accepted under Maryland law. So we settled it up here because he was a worker on a gas rig. It was a rather substantial injury. There was a large third-party case. We ended up mediating both the third party and the Pennsylvania workers' comp case all at the same time. But part of settlement in Pennsylvania was, hey, you're going to also settle the Maryland case, which we ended up doing for no additional money. And I sent a detailed letter because he didn't have an attorney in Maryland. So I was afraid when we tried to settle in Maryland, I was going to get kicked. So I did a detailed letter to the commission saying, listen, this should have never been accepted. He did receive benefits. I'm attaching everything from Pennsylvania so you can see what he received in Pennsylvania. And they ended up approving the settlement. But yeah, that was a case in which it should have only been accepted under Pennsylvania law because an injury happened in Pennsylvania. It was a Pennsylvania resident, and he never, I think, ever worked in Maryland. And I think it was picked up because it was a Maryland employer, which is not a reason to pick up a case.
And that's about those two exclusions in terms of the other state having the same exclusion that Maryland has, as well as the non-resident employee having coverage in another state. There was an employee injured in Maryland. He was just an incidental worker in Maryland, but he was an undocumented worker. And so he was a Virginia resident, undocumented. He wouldn't have coverage in Virginia, and therefore coverage wasn't excluded under Maryland. It was a compensable Maryland claim because of that.
And to sort of add on to when we're dealing with dual jurisdiction, if a claim is found to be compensable, maybe in both jurisdictions, if benefits were paid under Pennsylvania law, say, and then a Maryland claim is filed, you're going to receive credit for any benefits that you paid under Pennsylvania law. And the same works the other way.
Sure.
In that case that I had, we received a full credit for everything that was paid under Maryland law.
And that's why you want to, and you mentioned it, Steve, in terms of settling a claim in Pennsylvania and Maryland, you have cases where there might be jurisdiction in multiple jurisdictions. So you want to make sure you close them out. If you close it out in one state, then perhaps the guy or the person could refile in another state, and all you do is you get credit for the money that you paid to close it out in Maryland, or vice versa in Pennsylvania.
Correct, and that was our fear in that case. We wanted to make sure that the entire thing was closed out, and I think it worked to our benefit. In Maryland, again, maybe I'm jumping ahead, but if you settlements are allowed, it's really done by mail. Unlike Pennsylvania, where you have to go to a hearing and say, that's my signature, and I understand what I'm getting and what I'm giving up. Everything gets mailed into the commission in Maryland, and they make a decision sort of remotely, and you just get a decision in the mail. And sometimes, and that was my fear, was I wanted to get the Pennsylvania one resolved through a judge and then send everything into Maryland so they understood what was going on. And that seemed to work out.
That's right. I don't know, Steve, we can head into employer-employee relationship. And this, again, is a big area. I mean, that's a percentage of cases I handle are people that are misclassified as independent contractors when they're actually probably employees of your insured. So
yeah, and whenever you're talking about an employee versus an independent contractor, there are going to be, again, there's those tests where you have certain elements that need to be met. And Maryland indicates that if you're talking about employee versus independent contractor, that's going to be done on a case-by-case analysis, focusing on factors including, was there a contractor and agreement of hire, focusing on the intent of the parties, payment of wages, power of dismissal, power of control over conduct, whether the work is part of the regular business of the employer, and the skill required by that occupation. And the key factor in all that is the element of control and the degree of supervision exercised over the worker.
And that's what I have several claims that a subcontractor, whether it's flooring, roofing, or whatever, has employees, and that individual is paid by the job. And then that individual pays all the other people that are working for the subcontractor. But if the subcontractor doesn't have coverage, you're likely going to be nailed. I mean, this isn't it's a state system. The uninsured employers fund is going to be looking to see who up the chain of command is covered for workers' compensation and try to target that entity that has coverage.
Yeah, absolutely. That general contractor is going to be held to stand in the shoes of that subcontractor if that subcontractor is uninsured. And that's, I would say good business is to make sure all your subs, you can indicate in a contract that the subcontractors need to have workers' comp. You should make sure that you have to make sure you see that policy before letting them on a job site. And that's easier said than done. We all know what happened. We wouldn't have any cases if it was done properly. And you wouldn't have those cases with subcontractors if it was done properly. And you had mentioned earlier undocumented workers. In Maryland, undocumented workers are entitled to temporary total disability benefits. Interestingly enough, though, because they technically shouldn't be legally working, they are not entitled to vocational benefits. Correct, Jack?
Oh, that's correct, Steve. And how about Pennsylvania? I mean, there's a limitation there for Pennsylvania.
Well, yeah, absolutely. It would be the same thing in Pennsylvania. If you have an undocumented worker and they're out of work on TTD, they can receive the TTD. But once they're released to any type of light duty or other work, you could suspend benefits at that point. So, but in Pennsylvania, you typically get TTD much longer than you're going to get in Maryland.
That's right. And I think in Pennsylvania, sometimes you have a similar inquiry that, but for the illegal or the undocumented status, you would have a job for the person. So you may not even have to work for maximum medical improvement status before cutting someone off in Maryland for that.
Right. So, all right, well, why don't we move on and just talk a little bit about kind of the nuts and bolts of notice, things like that. Like, hey, I get hurt at work, what do I do? So I'm the injured worker and I'm lifting my box and I hurt myself. I need to give oral or written notice within 10 days of the injury. Or, God forbid, lifting that box killed me. 30 days, within 30 days of my death, the employer has to be given notice.
But I'll say in Maryland, the notice is a little squishy because you have to prove that you were prejudiced if you're trying to raise the notice issue to try to, avoid the claim. So I think a lot of times the commission doesn't even deal with the issue of notice based on that standard. The other thing is that getting into the 2-year statute of limitation for filing a claim, you want to make sure you're insured or your company files an employer's first report of injury with the commission. Until that first report of injury is filed with the commission, there is no statute of limitation that runs. So to toll that, you have to get that thing filed. And then another nuts and bolts kind of thing, and sorry, maybe I'm pushing ahead a little bit, but the until the employee claim has to be filed in order to pay wage loss benefits. So if you get a claim in and someone is wanting wage loss benefits, you got to make sure they file the employee claim. They can file it electronically. It's real easy. Some people will send it to the injured worker to have them mail it in if they can't file it electronically. But there's a penalty provision in Maryland. If you start paying wage loss benefits and there's no employee claim, just they don't want to lull injured workers into not filing claims and then later raising the statute of limitations or something like that.
Yeah, and I've always found that interesting in Maryland because I have several clients who want to be proactive, and I appreciate that. I appreciate that when you have a client that says, hey, this person was injured at work, I want to pay them. My first question always is, has there been a claim filed? Because if there hasn't, do not pay those benefits. Unfortunately, it's sort of a wait and see state. You need to get that employee claim filed, which then triggers the commission to send to the employer the form which indicates, hey, you accepting this claim, or you're going to be more or less denying it, and it gives you a drop dead date within which that needs to be filed. Until you get that, at least the claim form, do not pay benefits. And then it's good because it gives you the time. Once you get the form from the commission, you'll then have time to decide, yeah, we're going to pay this, pay it, and mark on the form, we're paying it as of this date. In Maryland, it's sort of you can keep coming back to the commission if you have to, right, Jack? You can file issues really at any time.
That's right. And we had a question in terms of, sorry, I'm trying to find it again.
Does that apply to self-insured employers, that question?
That's right, and it does.
Yeah.
I mean, if you don't have a first report of injury filed with the commission, then there's no tolling of the statute of limitations, and an employee claim should be filed with the commission before benefits are paid. I will say maybe for a self-insured employer, if there's a wage continuation process or something like that, that wouldn't apply, even though you would get $1, dollar credit before the commission if there is a later claim for temporary disability indemnity during that same period.
Right. And while we're talking about limitations, there's a limitation with regard to reopening a claimant's claim. So let's sort of jump ahead in the process. We've paid TTD, we hit MMI, benefits are cut off, we get a permanency rating. Once we have the last payment of compensation being made for that permanency rating, claimant still has another 5 years within which to reopen the claim and allege a worsening of their condition. So this is, I think, Jack, you always call it, it's sort of like whack-a-mole claims in Maryland.
Well, if they're represented by an attorney, they're going to go for permanency benefits.
Right.
If they're not represented by an attorney and you paid some wage loss benefits, the 5-year statute would run from the last payment of those wage loss benefits. And there's a case that it's not when you issue it, it's when they receive it. And so that's a little bugaboo that, so I've had a one case that came up, whether it was received or paid, and we got into that. And there's a case that deals with that. You have to show that they received it on a particular date, whether it's when they cashed it or what.
And then we have another question regarding whether the 5-year statute applies to medical benefits. There
Does
is
not.
no, go ahead. I was just going to say, there is no limitation on medical benefits.
There is, I mean, that's when you would get, if they come back years later, it would probably be denied, but then you're probably going to get into, you know, the fact that you may need a doctor to say, no, this is different. This is a new condition. This is unrelated to the prior condition, but you wouldn't be able to raise the statute of limitation on that. You have other defenses like medical defenses and things like that that we would have on any of these issues.
And we've got another question also. Is there a limit to the number of times a claimant can pursue an increase in their permanency rating?
Death.
What?
Death.
Death.
That's the limit.
How many, in your own experience, where's the most times you've seen people reopen cases? Because I've got one going on right now that's only the second time, I think, but there was a major surgery. So sort of understandable.
Well, I think some of these folks, I mean, if they're represented by an attorney, I think that's probably the standard practice, is to put a tickler on their file. And so just before the 5-year statute's going to run, someone's going to be knocking on your door saying, Mr. So-and-so or Mrs. So-and-so is having some increased symptoms. Will you authorize a return to multi-specialty or whatever? And they're working it up for a worsening condition. And then once they establish that, they're going to get a medical opinion that they're worse, and they're going to file. Now, one thing that's interesting, and a case came out not too long ago. In fact, I think it was in our case law update discussion. A lot of people, including me, are sort of annoyed when people file for worsening and they don't give you any medical. Right. And then it turns out they didn't even have any medical. The courts don't care about that. They can file for worsening, and as long as they file within the 5 years, it doesn't matter if their medical opinion is over the 5-year period. So we always thought that it was improper for people to go for worsening without a medical opinion, but the courts don't agree with that.
You just get it filed within the 5 years, then go get your opinion, right?
That's right. And that's what they do. I mean, that's what you're always, I mean, there's one particular law firm, they always do that. They never have their medical, and it turns out like 30 days before a hearing, they get a medical, and that's their medical to proceed. So then you have a question, do we get a medical or wait to get their medical? We normally like to wait to get their medical, and sometimes if
no, I agree. I mean, that and that's the other issue is, even when you're going before the commission, it's not as if they have to turn things over months in advance. So you're at that position where, well, do I show up at a hearing and not have my own medical to be able to defend it when they're going to hand me theirs 3 days before the hearing? You know, it's and there are no good answers to that. And that's also not to say that no cases settle in Maryland. You are able to fully resolve cases, but some attorneys, I've got clients who want to resolve, and claimants counsel it's crickets. They just don't even want to talk about it. Yeah.
Well, that's money in the bank.
Right.
If you get the right injured worker, in terms of every 5 years, you're going to be, going further and further. And when we get into the permanency benefits, I mean, it can be worth some pretty good money to let these things go on and on and on.
Absolutely. And not to give short shrift to medical benefits, but medicals are payable for the lifetime of an employee. And there is a fee guide created by the Workers' Compensation Commission as to what, as a carrier, you would need to pay. And there is, and any type, there's specific things you can do. This is sort of getting into the minutia, but if you don't agree with, if you decide to deny medical treatment, there's a whole process, that you have to go through with regard to the provider arguing you should be paying and you not paying. There's order nices that are filed, and then you can file, we would then be able to file issues and get it before the commission as to whether or not the treatment's related.
And they can, it's a claim for medical service or something. And so you have some of these outfits. Let's see, Steve, I don't know if you remember, it was like a year and a half or 2 years ago, they put a limitation period on presenting medical bills for reimbursement.
Yeah.
And when that limitation came into effect, which the commission has interpreted as not being a retroactive limitation, some of these medical providers are filing medical bills from like 15 years ago and going before the commission and getting reimbursed for some of this stuff that was never paid a long time ago.
And moving on, if payment of wage loss benefits. So if we've decided to accept a claim, the first question is, how much are we going to pay? And that would be based upon the claimant's average weekly wage. And in Maryland, the average weekly wage is based upon the 14 weeks of wages pre-injury, not including the week of injury. And that would also include salary, tips, bonuses, overtime, vacation pay, and room and board if you're one of those rare employers that is paying for room and board. And there is an exception in Maryland. If you're a volunteer, you're only going to get, if you're a true volunteer and you're volunteering your time, you can get medical benefits, but you're not going to get any wage loss benefits. And the procedure for filing is to file a wage statement at the inception of the claim. And this is something that happens, I swear I see it in every other case. When the employee files their claim, they're going to say what they believe their wages are per week. We then actually get the wages and find out, oh, it's $300 less. And then you get an order from the commission saying you need to pay at this rate, which is based upon what the employee alleged. Do you tell your clients to pay at that rate or pay at the actual correct rate?
Are you saying for the automatic award?
Yeah, the automatic award. There's an automatic award.
The automatic award, and that's actually a good point. A lot of people are concerned that the automatic award means something. It doesn't mean anything other than you've accepted a work injury. So you can later dispute the average weekly wage that's listed on the automatic award. You don't have to pay temporary disability indemnity that's listed on the automatic award. The automatic award just simply establishes that you have a work-related injury and you can dispute causation and things like that in the future. The other, just a little, that 14 week, I mean, Maryland uses 14 week, Pennsylvania uses a different calculation, like the last three highest 26 week or no 13 week periods. But it's all these systems are trying to get an accurate assessment of what the wages would be and have been. And so the 14 week, you have some of these situations where people were off work for 2 weeks because they had COVID and they're squawking that they don't want those 2 weeks included in the 14 week period. And so we get into these, I mean, if you go before the commission, they may veer from the 14 weeks if they don't think that's a fair assessment of what the wage loss is or the earning capacity is. The other thing in terms of the nuts and bolts, when these claims are set up, it'd be nice to get an accurate wage statement. Lots of times, some employers will calculate the wage statement using a different date from the date of injury, like maybe the first date of going off work. They'll calculate 14 weeks back from that period. And so you have a wage statement that doesn't make any sense. The other thing is, like Steve mentioned, they'll use the week for that included the date of injury. So that's not right either. So in just a housekeeping thing, it'd be nice to get an accurate wage statement going back 14 weeks from the week before the date of injury, so you can file that with the commission, because what you do want to do is file an accurate wage statement with the commission before it goes to the first hearing, because the commissioners are directed to make a finding on average weekly wage at the first hearing. So up until the first hearing, you can, argue about wage statements and all that kind of stuff, but you can't after that.
Jack, we've got two questions. Just backing up a little bit, you were talking about medical reimbursement limitations. The question is, what is the medical reimbursement limitation? Is it 1 year from the date of service?
And I may have to go back to that. I was going to ignore that question because I don't recall if it's a year or 2 years, but I can get that information and send it out. It's a statute that went into effect like a year or two ago. So,
and I don't know what it is off the top of my head either. So we will make sure that you get Karen, I believe it's Karen Robinson. We'll make sure you get that information. We will answer that question. And the second one is overtime included at the OT rate or straight time rate?
it would be, I mean, whatever it is, the overtime rate would apply. So if they're being paid overtime during that period of 14 weeks, you're going to get a wage statement that's based partially on that overtime assessment at the higher rate.
And if we're going to pay benefits and I'm out of work totally, that's called temporary total disability benefits, and that is paid at the rate of 2/3 the average weekly wage. There is a cap which changes every year in the state of Maryland. That's, I believe it's sometime in the beginning of January that's posted. But typically it's 2/3 the average weekly wage. And I'm just looking at the clock. We've got like 15 minutes left. So for TTD, as long as I'm out of work, I haven't reached MMI, you're paying me 2/3 of my average weekly wage. However, if I am released to go back, I'm not at MMI, Jack. My doctor has said, go back light duty. My employer has light duty available, offers it, I go back, but I'm not earning what I was earning before. I would then be entitled to 2/3 the difference between my average weekly wage and what I am earning on light duty. Correct, Jack?
Actually, it's 50% of the difference.
Oh my God. So I'm sorry. I'm sorry.
Well, Pennsylvania's 2/3.
That's my Pennsylvania coming at me. I'm sorry.
Yeah. So it's 50% of the difference, and that once they're at MMI, you don't have to worry about that. So even if they're not earning their pre-injury wage, if they're working, getting a partial as soon as they're at maximum medical improvement, you can cut that off. But maybe we'll head on, Steve, into permanency issues, which is a whole new ball of wax. Maryland has scheduled members just as other states do. So if you lose a thumb, it's worth some money. It's worth a number of weeks of wage loss benefits. If you lose a toe or an arm or things like that, it's a scheduled member. But I was looking on the commission website, statistically, I think 55% or more of the injuries in Maryland are non-scheduled injuries. So if you injure your neck, your back, your shoulder, things like that, it's non-scheduled. So if you have a doctor saying you have a 20% impairment to your back, you take that over 500 weeks and you come up with 100 weeks of compensation at, not getting ahead of ourselves, but in a tier rate. Maryland has tiers. So if you have a relatively small level of permanent disability, it may be less than 75 weeks. You have one rate for that. It's a lower rate. They call it a first tier rate. And for this year, that first tier rate is, let's see, what, $224 this year. If you have a second tier rate, which is worth from 75 weeks to 249 weeks, that benefit would be payable this year at a rate of, let me see, I'm trying to look at this schedule. It's $446. And then if you have anything over 249 weeks, meaning 250 weeks or more, that's a serious disability rate. So you have a higher compensation rate, but you also have a multiplier. So if you have disability of 250 weeks, you multiply that by a third. And so you're already up to like 320, 330 weeks or something at that higher rate. And that's how some of the claimants attorneys don't want to settle some of these claims, because these, down the road, these back injuries are going to start popping into higher rates, and you get more money down the road than you would otherwise, perhaps settling it now. So sorry
Right.
about that truncated
No,
spiel.
we have to sort of be truncated. But so what you're saying, Jack, also is that if I have a low back injury, and at first I have less than 75 weeks, let's say I have 74 weeks of disability, and that's a first tier. I don't settle my case, but within those 5 years, I say, oh, the back's gotten much worse. I'm then I can then have a doctor say, oh, well, now you've lost even, it's now more than, it's a higher percentage. So now you've been bumped up into 100 weeks of disability. So that I've already been paid the 75. So I don't get paid the first 75 or the first 74 again, correct?
That's correct.
I'd be paid the next 25 for that shot then.
But the next 25, you get the higher rate.
Correct.
So, and
so
then if,
right. I'm sorry, didn't mean to talk over.
Oh, no, not at all. I talked over you, but and it happens. I mean, it's a lot of times if you're close to a change in tier from like tier 1 to tier 2, you're going to be paying some extra money, because the claimant's attorney knows that it's not going to be real hard to get in another couple of years to pop over into the next tier level.
And let's say if we're not happy with let's say we're not happy with what the commission does, and we file that appeal and we get a jury trial, are we allowed to discuss that with the jury? The why we're fighting over weeks of compensation?
You can discuss the opinions, the medical opinions, expert opinions regarding the level of permanent impairment, but you can't talk about money figures to a jury.
Right.
The other thing I failed to mention is that, let's say you have an injury that they injure the neck, the back, the finger, and all this stuff. All this stuff gets rated out by the number of weeks, and then you add up the number of weeks. So you could have a relatively minor event affecting lots of different body parts. And if they could, add up to some real money, you could even get into tier 3 for like a finger, a back, a toe, a knee, all this stuff.
Yeah, and I think something else that we should bring up is apportionment. So let's say I'm a claimant who already had a fusion at L5S1, and I hurt myself again at work. The carrier and employer is only required to pay the amount of permanency that's actually due to the work injury, not that pre-existing condition. So we would need to get a medical opinion from a doctor indicating what percentage is apportioned to the work injury.
And the other thing is depending on the commissioner, you can get apportionment based on a degenerative back, even if you don't have a prior injury. So if they get an MRI, 10 days after a work injury, and it's degenerative, this and that, you can argue apportionment based on that MRI finding and having a medical opinion that, certain percentage of this problem is due to a pre-existing condition.
Right. And again, not to jump ahead too far too quickly, but I think we should also talk about voc rehab a little bit, because that's something that comes up in quite a few cases. So Jack, when am I entitled to voc rehab if I'm an injured worker?
Well,
if get back to work, Jack, I swear I want to get back to work, but I can't do what I was doing before, Jack.
Well, it's a squishy area there too, because I mean, the commission promotes vocational rehabilitation, so they have an expedited process if there's a dispute regarding whether or not someone's entitled to vocational rehabilitation benefits. You could be released back to your pre-injury job, but if it's no longer available, you could still be granted vocational rehabilitation. And so generally, the longer you're off work, the more likely you're going to be granted vocational rehabilitation benefits by the commission. One upside, I mean, I think voc rehab is probably worth $7 to $12 grand.
Mhm.
It's usually, 2 or 3 months of job placement services. So that's not, I mean, not that it's cheap, but I mean, other states, including years ago in California, we had cases where someone's being shipped off to Paris, France to study, you know, at the Cordon Bleu cooking school or something, or starting a camera business down in Bogota, Colombia, and things like that. So Maryland has a limited vocational rehabilitation benefit, but while they're in participating in vocational rehabilitation, you're paying a temporary total disability indemnity rate as a vocational benefit rate while they're in there. So it's going to add up to, like, I'd estimate like 7 to 12 grand every time they're granted that. And that can be something taken into account when you're trying to settle a case. As we speak, I'm trying to settle a case that's scheduled for hearing on Monday, and they're squawking about voc rehab, and it's worth some money to try to get rid of it before going into that process.
Yeah, because I've also found you need to keep, when someone is in voc rehab, make sure they're actually participating in that voc rehab. I've had plenty of cases where you're getting reports from the vocational counselor. Oh, he didn't show up. Oh, he showed up, but for whatever reason, isn't able to participate, or isn't interviewing, isn't even applying. And at that point, you need to try to cut them off. I mean, you need, and don't get me wrong, not all cases are like that. I've had other cases in which people have participated and found jobs out of voc rehab and are now working again. I mean, it does work.
Well, also, I would just, the voc rehab counselors, they're hard to give a definitive opinion one way or the other on whether someone's cooperating in vocational rehabilitation. And I had one case, I mean, that usually the commission will follow whatever the counselor says, but I had one case where the counselor was giving them like a 10-question test once a week. The guy really wanted back surgery, but to keep his benefits going, she was giving him, or he or whatever, like a test a week that probably took like an hour a week for voc rehab. We disputed it, and the commission, gonged the guy in terms of not participating in vocational rehabilitation services. So that's something to keep in mind. But the counselor is agreed to by the parties, so they're really cognizant of not wanting to, veer one way or the other in terms of cutting off benefits.
And we were talking about, we briefly talked about, hey, if someone's getting temporary total and they reached MMI, we can cut them off. Oh, hold on, before I start babbling, there is a question. Once an injured worker is at MMI but still has restrictions, do we still need to pay temp total or temp partial, or do those benefits stop while we work out the permanency?
Stop.
They stop. And I would tell you, that's actually exactly what I was going to say, is they stop, but just don't cut them off and don't file anything. We do need to file a form when we're stopping temporary total. It's called a C-06. And it more or less just says, we're stopping your temporary total disability benefits. And you file that if they have an attorney, make sure the attorney gets a copy, the claimant gets a copy, file it on the commission's website. And then, maybe issues will be filed, maybe they won't. But a lot of times, once they've reached MMI and they're no longer getting benefits, they are going to get their own IME and get their permanency rating, and then we would move forward and get an IME of our own.
And there's the C6 for terminating temporary total disability indemnity. There's also a C10 if you get an IME saying there's no need for further medical. You file the C10, you serve the claimant and the attorney and the medical provider who's providing the treatment that you're going to be denying from this day forward. So.
And same thing, if you are getting, if the claimant is still receiving medical treatment and you want to contest that medical treatment, I would say the best thing to do is to get an IME in that case, Jack, because you're going to want a medical opinion that is not related.
Well, I'd also say sometimes they file a claim for a neck and all of a sudden they're treating for a shoulder and a back and stuff like that. You can deny a causal relationship at any time, but if you want to go to the commission, you probably want to have, some some backup, whether it's a year's worth of treatment notes saying they didn't have any of this treatment for the first year, or whether there's a subsequent injury, or whether you get an IME and say this is unrelated to the work injury.
And just getting into the sort of the nuts and bolts of how you're going to obtain those medical records. We can use authorizations and subpoenas. We do have subpoena power in Maryland to get records via subpoena.
And so if the matter is not in litigation, the employee claim, once they file it, we're coming to about the end, but another thing to note about the employee claim is when they file that with the commission, on side 2 of the employee claim is a release for medical records.
Correct.
And so you have that ability to get medical records by release for the alleged injury. That's from day 1 when you get the employee claim. If you want to subpoena records, the matter needs to be before the commission. So issues need to be filed. If the matter isn't in litigation before the commission won't sign your subpoena. So that's something to keep in mind.
And we've got another question. Can claims be settled full and final to include medical, or is medical not able to be settled? You can settle everything. And again, so long as your claimant is not Medicare eligible, we don't have to deal with the Medicare set aside. But I've got a claim right now where an individual is Medicare eligible, and we are getting a proposed Medicare set aside to be funded, because the commission, many times when you're settling cases, they want a letter from a treating doctor indicating that there's no need for additional medical treatment.
That's right. Or you have an opinion that they're fully recovered. So even if they're not Medicare eligible, though, the commission is concerned about that issue. So they still want it to be addressed one way or the other, whether it's a medical set aside or whether you attach a medical report saying they don't need any more treatment. I think maybe now's about the time to thank everyone for showing up and listening to this. And I don't know, Steve, do you have, let's see, is there another question?
No, one more question. After a settlement, can they come back for permanent?
No, I mean, if it's a full and final settlement, you can settle everything, it's done. And if it's a stipulation or something less than a full and final settlement, then they might be able to come back for further benefits. But most of the settlements, they're either going to be a stipulation regarding permanency, or they're going to be a full and final settlement closing out everything. There wouldn't be a lot of reason to like do a settlement that doesn't include everything.
Correct. Okay, then with that, we will end it. I'm Steve. He's Jack. We both handle Maryland, Pennsylvania, Jackson, California. I also do DC. If you need anything, email us. That's what we're here for. And have
That's
a
right.
great. Right, I'm sorry. Have a great.
Oh no, and also just the outline for Maryland is on the firm website too. So if you have any questions, you're welcome to email or call either Steve or I or anyone
Absolutely.
else.
That's what.
Thank
we're
you
here
very
for.
much.
Take care, everybody.
Great.
Thanks
Thanks a
very much.
lot.